Good evening. Hi, let's get started slowly. Thank you all for coming today. It's been a day of multiple interactions, and I think just can attest to that. We took a long road to come to Glasgow today due to derailment and train incidents, and we're very thankful to have her here. Um, and so I will briefly introduce her and we'll start talking about the topic. So our idea today is to have a conversation and you can also join in. We didn't want to have a talk, we just wanted to have a discussion. Um, and we thought that was important and fitting to the topic as well. So having a co-production of knowledge and an exchange rather than a talk. So Dr. Jessica Lynn Corsi is senior lecturer in St. George Law School in London and is the co-founder and co-chair of the working group on gender parity for the International Court of Justice. And today we're going to talk about this issue, gender parity in the ICJ and feminist judging, and we'll tease out the difference between the two, and we'll also talk about how to achieve and how we're thinking and acting in this regard. So first of all, Jessica, I would like to ask you, how did you come to co-found the working group? What was your trajectory? What led you to this? And what has been done so far? If you can give an introduction to the work of the working group.
Sure. Thank you, Martina, who's a steering committee member on the working group and has participated in our recent September Hague workshop and also supported a lot behind the scenes in New York at International Law Week, running a United Nations Sixth Committee side event. Oh, I'm going to project a little bit more. Thank you. Can everyone hear me? More or less? Good. Thank you. And so Martina was supporting the working group in our work behind the scenes. So thank you for that. Thank you all for being here tonight. And thank you for the invitation to be here. So I've always been interested in gender equality and the United Nations and the International Court of Justice. Since I was a teenager, actually, it's a strange, long interest. And how I came to work on this project to achieve gender parity for the International Court of Justice and to co-found the working group, which is an international, transnational, feminist, intersectional network of scholars and practitioners, diplomats and lawyers, judges and political scientists, and of course academics like us, civil society members, civil society partners, and students. We have a lot of students, law students working with us and involved. It's through a series of meetings. So I always had an interest. I had an interest in gender equality and international law in every sense, both the substance of international law. I'm based in London. I'm at the University of London, City St. George's University of London, the City Law School. And I'm a member since 2014 of a network called the Atlas Network. So if people here are interested in international law, it stands for Acting Together Law Advice Support. And it's a network of almost 10,000 women around the world working in international law. So in 2016, through the network in London, I was invited to some meetings and I met the civil society group GEQUAL, which was founded in 2015. And GEQUAL, gender equal, it stands for gender parity in international representation, which includes the International Court of Justice and all other international courts. It also includes regional courts, and it includes the special procedures at the United Nations. So special rapporteurs, special experts, and other appointments at the international and the regional level. And they founded themselves in 2015, and they thought, surely we'll achieve gender equality and everything in the next couple of years. And it hasn't happened yet, which is why we're still working. So I got invited through this network, so the power of networks, the power of coalitions, the power of working groups, international networks, to some meetings. I had a lot of ideas about how we might move forward with gender parity, which means 50-50, or it means equal gender representation. So in the gender binary, man, woman, that's 50-50. Some people in the world live outside the gender binary, not everyone is a man or a woman, so it means equal representation of everyone's genders in all political decision-making, including the judiciary and all the parts of the court, judicial clerks, registry, and other decision-making powers. So I happened to have a lot of ideas, and they said, why don't you work on this with us? So I did, and I ran a workshop for them in The Hague on the topic, and we had great ideas, and not a lot of traction, right? So again, you start off with this optimism. Oh, the law obligates you to have gender parity in your judges. Surely we'll just remind you that you have a legal obligation, but of course, that's not the way that the law works, right? And so the reason that I co-founded the working group with someone from Glasgow, Dr. Gail Lithgow, who's based in Glasgow but teaches at Edinburgh University, is because working out of this broader movement for gender parity in international courts and representation, we came to find out that the judicial nomination and election process for the International Court of Justice specifically was so particular, so political, and so challenging that it deserved its own focus. We're moving slowly, but we are moving. So since we started working on this in 2016, there's been an election of 2 additional women to the court. So the International Court of Justice, the UN's court established when the UN was established, predecessor to the Permanent Court of International Justice, the World Court, the court that hears things about genocide and sea rise and climate change and human rights and border disputes, the court where states go to peacefully resolve disputes. It has 15 permanent judges. From 1945 to 1995, 100% of them were men, 100% for the first 50 years. 1995, the first appointment. Since we began working on this in 2016, we have a record high of women judges. It's 4 out of 15. It's not even 1/3 of the court, but we have seen some incremental progress. So the way I came to found it is the way we work, through networks of women lawyers and practitioners, through networks of academics and scholars sharing ideas about how to turn legal obligations into reality. And then again, the realization, which we can talk more about, that the process for achieving gender parity at the International Court of Justice faces a lot of challenges. As you might imagine, that the World Court, with so many member states and so many UN organs involved in the process, would result in a really complex procedure and process.
Yes, thank you so much for giving us this introduction. So, as you rightly mentioned, this is a very complex system, and it is not something where you just affirm the obligations, the legal obligations, and then states follow suit. How do you think the network is achieving its goals, and what are the activities apart from creating networks and having discussions? How do you think this can be achieved on a practical level?
Yeah, that's a really difficult question to answer, but I'm going to try, and it's a constantly evolving answer as well.
Yeah.
So I work interdisciplinarily as well and cross-disciplinarily. So the idea that the court, the International Court of Justice, or any justice system or any court operates in a complex system comes from the social sciences and complex systems theory. And if you think about any court, even your local court in Glasgow, there's so many actors that are involved, right? There's so many, there's the legislation, and there's the police maybe, or there's the lawyers, and there's the judges. So one thing we did is we mapped the system. So who actually makes the decisions, who nominates the judges. So you need to know a lot about the court. So what controls the nomination and election? The starting point is the statute of the court. So various articles of the statute of the International Court of Justice tell us how the election procedure works. But I think most people in here study law or read law, practice law. So you know that a lot of law is very vague, right? So a lot of the procedure written in the ICJ statute about how judges are nominated and elected is quite vague and open texture, which you could say could work for us, right? So that's the starting point. The statute itself maps out the actors. The Secretary General of the United Nations is supposed to open the call for elections. 1/3 of the court, so 5 of the 15 seats, will open for re-election every 3 years. They usually do it in November. So the next regular election is November 2026. They're about to have a casual election, if you want to watch that, meaning 1 seat has opened up outside of term time. 2 men are up for that seat and 1 woman, Professor Phoebe Okawa, International Law Commissioner, and we're going to get the results on the 12th of November. So watch that space. So the statute says every 3 years, 5 of the 15 permanent seats will open for re-election. It says the United Nations Secretary General opens the call. Then it says a request of permanent court of arbitration national groups, who are they, or their equivalents, to nominate people. So the permanent court of arbitration is a Hague court. It shares the building in the Hague in the Peace Palace with the International Court of Justice. It was established several decades before, and like it says in the name, it's where states go to arbitrate. So we were just there. So we were there for a workshop in this project on the 20th, and we were inside the court on the 19th of September, and they were arbitrating, and that was really fun. So national groups, meaning, for example, the United Kingdom, they don't have to, can have at least 4 members of national groups in the Permanent Court of Arbitration. So if you look up who the 4 members are for the UK, they're very illustrious former Supreme Court judges and senior professors. And actually it's an interesting one for the UK because it's 2 women and 2 men, because most PCA national groups are all men. So that's an issue as well. So they'll nominate you. So UK came out early. It was the earliest nomination for the 2026, November 2026 election. They really want their seat. The 5 permanent members of the Supreme Court Security Council think that they have a seat on the International Court of Justice. They don't officially have a seat, but they campaign hard. So the national groups for the PCA will then nominate someone. How do they nominate someone? They won't tell us. So at the national level, it's not a transparent process. So I've personally spoken to the members of many national groups and legal ministers. And so, for example, in the UK, the legal minister told me, I promise you, it was a fair process. I promise you, women were interviewed. The women members of the PCA national group also told me, oh, I promise you, women were interviewed. We picked the best person, who is Professor Jacqueline Conde, illustrious professor of international law commissioner, obviously extremely erudite and skilled and practiced before the International Court of Justice. So how does it happen? We don't know. And it was an entire research project years ago funded by the Arts and Humanities Research Council, trying to get some information about it, but it's not transparent. Okay, so they make the nominations. And then states will make co-nominations to strengthen the international community's support of one candidate. And then the candidates campaign. They make videos that they post online, and they travel to New York if they can. So some of the candidates can't afford to travel to New York. Their countries can't afford to send them there. So I was just in International Law Week. So the very wealthy countries, the UK has nominated someone, France has nominated someone, Singapore has nominated someone. They hold these big receptions. In New York, they hold them often. Singapore was down on the floor in the United Nations Trusteeship Council passing out snacks as part of their campaign. Their campaign. So you can influence state nominations. What's our strategy? We've tried to, for example, work with the United Kingdom. We've tried to get more transparency in that. We've tried to work with national group members. We've sent them letters. We've had meetings with them. We've invited them to talk with us and so on. And then once the nominations are out, we don't know if the nominations are done yet. They haven't officially closed the nominations. Right now, there are 11 nominations. Does anyone want to guess how many out of the 11 are women? 3. So 3 of the nominees are women, the other 8 are men. One of the women, she's nowhere to be found because her country is not able to fund her to, people don't even know she's running. We only know because we're monitoring everything, trying to keep track. So how do we influence? And then where does it go? So we've got the nominees. They're in New York. They're campaigning. They're flying all around the world if they can afford to. Because who's making the decisions? That also varies country by country. Some countries will assign their election officers at their permanent missions in the United Nations to make that decision. Some countries will do it out of their Ministry of Foreign Affairs or another official of their capitals. In South Africa, you have to go to all 3 capitals to campaign. It really varies country by country, so it's a very complex system and it's not transparent. And then there's the actual voting, which again is governed by the statute of the International Court of Justice. And that happens in November 2026, separately between the United Nations General Assembly and the United Nations Security Council, and they vote in rounds. And they'll update like on the UN website during the day, the next couple of days, and they have to keep voting until they come to some agreement. Question, do you think that since we've been working on this the last 10 years, The Security Council and the General Assembly have voted in every woman candidate that's been nominated. No, no. So you see how are we trying to affect? We're trying to affect the nominations. We're trying to affect the voting, and we're also trying to affect the rules and the regulations and the laws. As there are 14 countries in the world that have officially right now that have officially a feminist foreign policy, for example. So that's one way to influence. If you can get a country to agree at a national level that they believe they have a legal obligation for gender parity in international appointments, you might have more influence in who they nominate. If you can get them to agree in their co-nominations that this is a good thing, this is a good idea, if you can get them to agree to a certain voting pattern. We're trying to work with the UN Secretary General. The International Law Commission just tried that, didn't work. They're less gender equal than the International Court of Justice. They've had less women and they have less women. And so last year for their elections, they tried to get they had the Secretary General of the United Nations put out a public call that gender parity matters and why there are legal obligations and why it's important. Then they thought if they made the nominations and the voting transparent day by day, that might influence it. This time around, it didn't result in more women being elected to the IFC. So how are we trying to work? We have to understand the system, which as you can hear is very complex. We're talking hundreds and hundreds of actors, right? Between the national groups and the national capitals and the people of the UN. We'd like to remind them of their legal obligations. We'd like them to enshrine their legal obligations into their national laws and policies and practice. I've suggested before that the UN General Assembly and the UN Security Council can amend their rules of procedure. So they can put something into their rules of procedure that obligates them to have a certain voting pattern. They haven't done that yet. So we're working from different angles. And I mentioned that we were just in New York. So we have a working group full of very just brilliant people, and they have a lot of experience. They're global. They come from every sector, and they suggested to us at a meeting we held in 2023 that we should try using United Nations side events during key weeks like International Law Week, where all the people that would vote for a lot of the people that would nominate and vote for the judges of the International Court of Justice will be. So this is our second one we just held last Friday. And the idea is to get states in the room. So we have 4 state co-sponsors: Singapore, Mexico, Sweden, and Canada. Thank you. I was like, why am I forgetting our 4th one? Canada. And you want to get states in the room talking about it. You want them to read we make a concept note. They post it on the United Nations website. I fill it full of law, references to specific paragraphs of specific legal obligations. You want them talking about it. You want them reading it. You want them putting it on the agenda. Again, is that actually translating into change? Little by little by little. So we have a lot of ideas. We're civil society. And this is a United Nations process and a national process. So it relies a lot on our ability to influence these actors because we're not the ones making a decision. So we keep thinking, we keep trying. We're always open to ideas, open to any suggestions, open to any connections that you know.
Yeah, I want to turn a little bit in this connection between something to procedure. You said we're a civil society, and I want to refer to sort of mistake probably we made by trying to portray our event as being sponsored by the working group rather than by a government, which led to the event being advertised at a different section of the 6th committee website. So essentially what would happen, it would be on the top of the list along with the other side events if it was just sponsored by states and officially the name of the working group was not first and foremost. But we wanted to be center and front, and we thought that just by saying that the working group is organizing events co-sponsored, that would create more visibility. And then it led to it being listed lower below among other events. So you see the gravity of something being state-sponsored, something being promoted or like named and labeled differently for the exact same event, being ranked differently and being perceived differently. So it's a learning process and it's a multi-level process and strategy in a very complex system.
Yeah.
but I also wanted to tease out some substantive issues. You were mentioning the distinction between hard and soft topics and their perception in at the UN. Can you talk a bit more about that and explain why?
Yes, so the workshop Martina was out in The Hague on the 20th. A lot of themes came out from a great roundtable discussion throughout the day. And one of them was that people feel, and I think it's quite obvious in international law, substance and practice, that any issue related to gender is siloed, it's set to the side, women and children set to the side, and it's hard versus soft. So gender is soft, but hard law is investment law, it's arbitration, I saw that at International Law Week. For the second International Law Week, it's an official UN week. You can look it up if you want. It's where the International Law Commission meets and briefs the sixth committee. And they have an agenda for all the topics in international law they want to talk about. Gender was not on the agenda, except for us. So for the second year in a row, we were the only official side that were briefing to discuss gender. And they discussed many important things. The draft convention on crimes against humanity, the increasing use of Article 51 of the United Nations Charter, the latest International Law Commission's findings on sea level rise, the latest climate change decision from the International Court of Justice. These are very important international law topics. And they continually are the only ones. Anything without gender is what gets talked about at the International Law Commission, the Sixth Committee, and the International Court of Justice. So it's not even considered. It's just not even there. And it could be in so many places. So the crimes against humanity involve gender very frequently. Sea level rise affects different genders differently. We could go on, right? Climate change affects different genders differently. There's gender differentiated outcomes and therefore gender differentiated legal obligations. But it's hard to get on the agenda. So what are our strategies? We have a lot of hopes and then we work what happens. And one of the good things that happened at 4 p.m. on Friday the 31st was quite a few women legal ministers came to us and said, let's put you on the official agenda. Because the United Nations, if you're familiar with it, anytime a treaty meets, including outside the United Nations system, or there's these standardized weeks, International Law Week, High Level Week, General Assembly, Business and Human Rights, etc., there's always something organized on the margins because everybody will be in town at the same time, focused on the same topic. So it's a great time to get people in the room to talk about your side issue, your side event, right? Or to brief them. And then there's, of course, the official agenda. And they're kept different places on the website. They're given different resources, one gets on UN TV and one doesn't. One is recorded and one isn't. One has all the states facing it and asking questions about it. And when, you're happy for whichever states show up and participate. So we're not on the agenda. There was appetite for putting us on the agenda. We have to strategize about how to do it. We need it. It's not up to us ultimately. And so it's convincing people, the right people that hold the power over these meetings, that this is a topic worthy of being on the agenda. And can I just say also, I think I might have told you this, I might not have, because, I was just in New York, I was just on the train, 3 trains to go. Mm-hmm. There were a lot of jokes made during the week about the lack of gender representativeness from the ICJ. So the International Court of Justice does not usually show up en masse to International Law Week, but they did this year because they turned 80. I mean, you held a conference this year on the ICJ turning 80. It's an inflection point. We're saying 80 years on, where are we? Where are we going? So the president of the International Court of Justice came, multiple judges from the International Court of Justice came, the registrar from the International Court of Justice came, which if you're a student and you ever practice, become friends with the registrar, right? They're very important. The registry of court is very important. And they were all men. And so when the International Court of Justice gave its first briefing Tuesday, 1:15 p.m., conference room 5, somebody asked, why are you all men? And before that, the male judges had been talking about representativeness. The court must be representative. They meant geographically. Mm-hmm. They meant a couple people from Europe and a couple from Africa, even though there's more in Africa, etc. Right? That's what they meant. And a woman said, why are there no more women from civil society? Because there's more flexibility from civil society. Why aren't there more women on the court? And why are you all men? And the room laughed. And the president says, well, it's up to member states to decide who's on the court. And he said, as to why we are all men today, no women judges volunteered to come to New York. And I was like, that's not funny. Everyone laughed again. That's not funny. I don't know if it's true. It ignores structural barriers. And if it was reversed, if it was 11 women and 4 men on the court, you wouldn't find yourself in that situation. Every Friday morning in International Law Week, the president of the International Court of Justice gives an address. In his presentation, right before our side of it, he misled the audience by citing data from UN Women and the UN Secretary General, which tracks the UN gender parity policy. And it measures gender parity in the different institutions and organs of the United Nations. It doesn't measure judges, judicial clerks, or the registry at the International Court of Justice. I had a meeting with UN Women that group to talk about why and how we can maybe start measuring what we can do. So when you measure they measure all the interns. When you measure all the interns, when you measure all the administrative staff, when you measure all the support staff, the International Court of Justice on the graph for gender parity data at the United Nations comes out slightly more female. So the president of the International Court of Justice stood up in front of everyone and said, there's more women at the International Court of Justice. Maybe we need more men. Which is one of the most disingenuous. I mean, I should really watch my language, but the audacity. Sitting in an everyone he brought with him is a man, and he knows his court is over 2/3 men. Over 2/3 men. He knows that. His registry is almost entirely men, and he knows that. There's never been a woman registrar of the court, and he knows that. That's not funny. That's not funny.
Jessica, is it also the case that interns at the UN are not paid?
It depends, but a lot of the time, yeah. Sometimes they're paid from their country.
Yeah, in the case of the International Court of Justice, you have officials of the court that would be paid by the UN. So the PQs that are assisting the judges, and you have judicial fellows that are sponsored by the university, so they're paid by the university rather than by the UN. There is a fund that supports certain students from certain backgrounds of the countries, both by country. But in general, I think the problem is the structural thing, obviously. But in any case, we are talking about the highest level, and you are comparing and putting in other kinds of positions. That's not comparable.
It's not comparable. And not only are we not on the agenda, but we're at some punchline. No. Inequality is a joke. Our lack of equal inclusion is humorous.
And it's really, I was really looking, because today we also have the second trend of like feminist judging and the comparison between parity and feminist judging, and we'll go to that. But I was thinking about when Judge Donahue was at the International Law Week 2 years ago, and she, in her statement, made a statement about the rules of the court changing and becoming more gender inclusive. So the was in this stage, it was markedly different. So you can see already, though there is no general association between Judge Donahue and feminist judging, that there is with Judge Charlesworth, for example, through her scholarship, you can see already that having a woman there talking about the rules of the court and how the procedure has changed, that this is really altering the presentation to the outer world. You don't have a man joking about the court being female. So yeah, I think then let's move to the issue of, and we have discussed a lot about that.
Yeah.
People talking about whether it needs to be gender parity or what's the difference between like just having women there, is that enough?
Right.
Yeah. Do you want to talk about these differences?
Yeah, I think it's important. So since we started meeting as a working group, it's come out a lot. People will raise the question, isn't it better to have a progressive man as a judge or a feminist male judge than it would be to have a woman judge that is against gender progress or gender-based rights or something like that? I think for me, it's really important. And I framed the talk in terms of international human rights law, and not only international human rights law, but transformational equality. So we can say a little bit about that. So formal equality, the law can't officially discriminate. The law doesn't. And there's nothing in the statute of the International Court of Justice that says no women allowed or no gender queer people allowed. Substantive equality, you have to make it equal in fact. right? Transformative equality, you have to pull people from the margins, you have to have structural change, you have to have reparations, you have to, there's many more aspects of transform around the issue, including temporary special measures. So for me, it's really important to, even though I do believe they're related, and our working group is feminist and intersectionally feminist, it's very important for me to look at the human right to gender parity in all decision making, including international courts and domestic courts, distinctly from what I think is the human rights obligation that all judges have gender competence in their judging, so that they do not gender discriminate in their judging, which sometimes is a synonym for, it's not identical, but gender sensitivity, gender competence, or in the language of the Rome Statute and the International Criminal Court, particular expertise in issues affecting women and children, because many states negotiating that hate the word gender and the concept of gender. So however you approach it, I think there's an international human rights obligation for judges to have gender competence. That's one human right. Or that's one manifestation of the human right, which we find everywhere. In all international human rights instruments, in the UN Charter and regional human rights instruments and so forth, and we find it domestically as well, that calls for equality and prohibits discrimination on numerous grounds, including gender, sex or gender. And that's one manifestation of the right, that judges have to have gender competence so that they don't discriminate, so that they have equal judging, right? That they can take what is the substance before them and make fair and just decisions, which requires gender competence and all sorts of competence. And that is separate yet related manifestation from that same right as gender parity. So gender parity is the evolved gender equality, right? So numerous bodies like the CEDAW committee have been articulating gender parity as the definition of gender equality in inclusion in decision making since the 90s. So we have dozens of documents from the 90s, and most recently, General Recommendation 40 of the CEDAW committee from October 2024. 25th of October, it was released the morning of our signing last year. We felt like that was a good omen. And then the Secretary General of the United Nations also tweeted that gender parity, we all have to have gender parity throughout the UN the morning of our signing last year. It's the most evolved, the apex interpretation we have from our international human rights legal system on interpreting gender parity. So that is one manifestation of the right to equality and non-discrimination, which addresses gender and disability and age and religion, ethnicity and migration status and everything. So for gender, one right is gender parity. And that's just because we're human. So if you're human, you have an equal and inclusive right to participate in all decision making, whether that's here at your university, whether that's in your profession, whether that's in the economy, whether that's in your domestic government, or whether that's in your international court. And that's one manifestation. And then gender competence for judges or feminist judging, when feminist judges, that's another manifestation. So sometimes people pit them against each other in scholarship, at meetings, and they say, we don't want more women, stop focusing on that. We want more feminist women. And we do, but there's no gatekeeping for the human right to equal and inclusive participation in decision making. Every human being has an equal and inclusive right to decision making, and you don't screen them. You screen them per the statute and per other judicial regulations for judicial competency. You don't screen them for all of their beliefs. However, again, I think there's a very strong argument to be made, which hasn't been clearly made, that gender equality law under international human rights law and domestic human rights law, regional human rights law, mandates gender competency in judging. And we've been looking at that. The working group partnered with feminist judgments in international law, and we're working together. And we've been looking at how, trainings at the International Court of Justice, manuals for judges, guidelines for judges modeled after domestic guidelines. So it's achievable. Gender competence in judging is achievable. The International Criminal Court is leading the way in international courts for that. And it shouldn't get in the way. That goal shouldn't get in the way. People shouldn't be saying more Norwegian men that understand gender parity, you know, gender, no more African women who don't understand equality. Those are related yet separate things. We have a right to be at the table, full stop.
Yes, and I think this is what we need to bring out, that you cannot pick these things one against another, and you can fight for them separately and on different grounds. And that's another deflection. Obviously, you have some substantive commitments, be it feminism or other goals, but that doesn't interact with wanting to achieve parity and equal representation.
It doesn't for the working group, and I think strictly legally it doesn't. It does for some people. Some people are very against the arguments for parity.
Yeah.
We are obviously not. It's our mission.
No, but that's what I'm saying is a deflection, is that these things really do not interact. There, I think, of course, you can understand where they intersect, but they don't influence one another. If you are not screening status for other beliefs, why would you do this in specific?
So one of the things that came out at International Law Week and in the workshop in The Hague, people were very surprised. We had a Chatham House rule discussion, so I'm not attributing it to anyone, but reporting on it. The workshop, there was a discussion on how surprised people were that Judge Hilary Charlesworth from Australia, excellent international judge, international law scholar, was appointed because for decades she has published feminist scholarship. And people thought, surely they're not going to vote for someone who has the word feminist in all of her writing. And they did, and people were blown away that she got in. I mean, she's just very skilled, and she's just great on the job. But this came out at our side event as well. Why is gender competence in international law not competence in international law? It's hard law. CEDAW, the Convention to End Discrimination in All Forms Against Women, is law. It's ratified by 189 countries. It's been enforced for decades. So why is that not okay? Why is that something to go? And I'm speaking behind the scenes to the women candidates, and they can't mention gender. They have to mention, you know, their all of the cases they've worked on, all of the other topics, the hard topics. But it came out, my side event, people were saying, the male international judges can be very specialized in their expertise and their practice and their scholarship in public international law, and no one holds that against them.
And in our event in The Hague, there was also this opinion being expressed that then Hilary Charlesworth had to be presented as also a more generalist lawyer, which she is. And so people were highlighting, no, she's not just a feminist. So she also knows other things, as if one cancels out the other. So she had to prove that she's a good generalist and not just a feminist lawyer in order for her to be accepted and admitted at the same standing. So you could see the double standards and the scrutiny that her opinions and decisions received under this light. But having said that, I want us to discuss a little bit about what feminist judging can bring, and bring it back to her opinion in the advisory opinion of 2024 Palestine. So there we had the first, I think, clearly feminist opinion being made, and not only mentioning gender and sex, but also mentioning intersectionality, and also bringing it back to the realities on the ground. So how the access to water affects primarily women and girls, and how rights to movement and all of these things are specifically affect girls and women. So what do you have to say with regards to that? How does it help? Does it counter our goals? You know what I mean? This dynamic of, in the end, having an effect in the actual judgment.
I think it's mixed in terms of, does it help our goals or not? I love to see it. It's 80 years in the making. I think technically 79 at this point since they started operating, but it's almost 80 years in the making that any judge in the International Court of Justice would acknowledge that conflict affects different genders differently, and that different genders are playing different roles in society. fetching the water, cooking the food, nursing the children, and so on. That's a really long time to wait for your lived experience, to wait for your reality to show up in international law at the most important world court. So it's completely overdue. And so for me, it's an excellent thing that she did, and it should be done all the time. And there might be a CEDAW case, there might be an Afghanistan gender persecution case before the International Court of Justice. Let's wait and see. And that would be the very first time that the International Court of Justice ever dealt with an explicit gender issue and ever dealt with CEDAW, Convention on Discrimination in all forms against women. I think just like we get people debating, do you really want more women judges, or would you rather have a feminist judge of any gender? We also get people debating whether or not men and women judge differently. There are many studies on whether they do, and they do. So every empirical data-driven study that is almost every, there's some that say they don't, will show some differences. And there's a type of differences you would expect. So there are different decisions in custody, decisions in family court. There are different decisions in sexual violence cases affecting primarily women and girls. There are different decisions in sentencing. It's not universal. It's not every issue. It's not every case. It's not every law. And there's not, I wouldn't say there's a huge amount of data, at least in the English language that I'm reading the research on. If anyone knows if there's like another language where there's loads of empirical studies about differences in gender and judging, please let us know. But it is there, and it's debated. And I personally, I think for our strategy, I'm not sure it helps us to focus on that. Because again, our foundation, our legal foundation for our working group is there is a fundamental, obligatory human right to equal and inclusive access to decision making and participation in decision making, regardless of whether you judge the same or differently than any other sex or gender or ethnicity or nationality or religion. And I think it's important that different judges judge different. I think it's also obvious that different judges judge differently, whether it's your socioeconomic background or your age or your political orientations. I think this farce that judges aren't human beings can stretch too far. And yeah, I think we need to be real. I mean, obviously, judges are doing their utmost best to be objective and stick to the law. They're not robots. They're not automatons. You don't program a judge and they spit out formulaic judgment. There's obviously judicial discretion, right? And changing circumstances and the evolution of the law and judicial interpretation. And so are there differences in judging between different genders? The data says yes. The scholarship says yes. The anecdotes say yes. Our observations say yes. Does that help us achieve gender parity at the International Court of Justice? I'm not sure. And I'm cautious about instrumentalist arguments, like, UN Security Resolution 1325 2000. Women deserve an equal seat at the peacemaking table because women make peace. Because there are facts. Who starts war? Empirically observed who started the war, right? Who continues the work. And then there's gender essentialism and gender, these are hard, there are tensions here. So I'm not sure that focusing, I'm open, I'm flexible, I could change my mind, we can adapt and move with that, but I'm not sure that focusing on differences in gender judging helps our campaign for gender parity.
No, for sure not. And as you said, you have to be strategic and you have to, focus on what matters and not conflate too many issues in an already complex system. And the goal is to achieve gender parity and not to screen for specific kind of opinions, as you said. And this is not, and this is why I'm saying even that Starford then has to embed this criticism in the larger framework and not silo off the feminist aspect. And that's helpful and useful, but that's not connected to the goal of parity. That's not linked to that. But I'm saying that counterintuitively, these points might be less helpful because of differences in subject, as you mentioned. And also, I'm not sure whether the empirical research on the domestic level neatly kind of transfers to the international level. It's a completely different scenery. And also, I'm not sure whether gender plays as much role as education. And you have different dozens of different nationalities being educated in the same universities, being socialized in the same circles. I mean, the scenery sociologically is different. And even if we look at their nationalities and race and religion and sex and gender and all of these things, there are other factors that are very influential.
Yeah.
So, yes, but this is why you also focus on the legal implications there.
We try. We try to bring people back to the legal obligations because we think there's a firm foundation there and we think it's clear. And like I said, the CEDAW committee has once again pronounced it with clarity and precision in their general recommendation 40 of 2024. There's no ambiguity. It was building on general recommendation 23 of 1997, which said something very similar. It's like, what's our strategy? What's our timeline? 97, 2024. Make the progress as you can. So I think the law has been very clearly articulated. But again, what is persuasive to people? What will persuade people to actually make those nominations and obviously qualified women. Though let's be clear, there are eight qualified women to sit on the International Court of Justice on the planet of 9 billion people there. there are 8 qualified women, right? So obviously they have every qualification you could need to be a judge of the International Court of Justice, and they are also women.
I want to encourage questions from the audience because I think we're not like here.
Can I ask a question for Libby? Sorry, this is a very interesting picture. Also, thank you very much. It's just a quick question about the legal obligation. Obligation of whom?
Yeah.
Because it's obligation to nominate them the space, and then the level can be decided differently, or it's obligation of the organ who's going to select.
Yeah.
Who's going to be judges? So
Yeah.
obligation. Then that obligation sources from whom?
Yeah.
What are the sources of these obligations?
Right. I review in my scholarship that it falls on everybody. It falls on the member states, and then the sources are the charter and the treaties they've signed, and the obligations they've undertaken also to translate the international law, whether it's CEDAW, whether it's the ICCPR, ICSRC, I have C on there. And whether it's the UN Charter, whether it's etc., it falls on the member states.
Okay.
And then it falls on the organs as well, and that comes from the law of international organizations, the internal law, so the customary internal law of international organizations derived from the charter, derived from also the UN Gender Parity policy, which started in the 1970s. So there's so much documentation on that, which is one reason why I'm trying to work with UN Women and the UN Secretary General to start measuring the whole court.
Yeah.
Because right now they only apply the decades-old gender parity policy, which they say obligates the whole UN based on the charter, based on specific judgments, and whether from the ICJ or whether from the UN internal administrative system, based on different decisions that have been made at the UN. So I say it falls on the states. As member states of the United Nations, and also on political organs that have responsibility. So without, just do you have power to affect the change? Yes, you do. You derive responsibility that way. And I say it's an obligation of conduct and result.
Yeah.
Yeah, so everyone involved deriving from various similar but not identical sources.
Yeah. Okay, thank you. It's not easy that one for establish the obligation of organization.
So one thing that I found in exploring, so what are our strategies, right? So who nominates, and then who makes the decisions? The member states are acting through the General Assembly and through the Security Council.
Yeah.
So even though there's an organ, so it's the organ itself that could modify its rules of procedure or something else, it's the member states voting as member states when they actually cast the vote for who's going to be the judge. So it's happening simultaneously at 2 different levels, I think. I found that I mean, there's probably a lot of international law scholars in this room or students. I found when I was exploring this that the law of international organizations is underdeveloped and that the customary internal law of international organizations is underdeveloped. However, the United Nations has an explicit gender parity, UN-wide gender parity policy that they've been developing since the 70s. That comes from the highest level. And so that makes it a bit easier. So we're not inventing UN obligations for gender parity out of the blue. They've already interpreted the charter and other legal obligations internal to the UN to create gender parity, obligate gender parity. They just haven't applied it to the judges or the clerks or the registry, and we still don't know why. Yeah.
No, we don't.
Did that answer your question?
Yeah, of course.
Yeah.
Thank you.
Anyone else? Even general questions.
Hi, great talk at the end here.
Thank you.
So when you talk about, you mentioned that there's debate on whether there should be more women or there should be more feminist women at, on the bench or in the organizations.
Yeah.
I sort of don't understand why one always looks at women representation as woman judge for women issues.
Yeah.
When you said about competence,
Yeah.
it's not just for like, oh, you need a woman. It's a judge, not a midwife.
Yeah.
I need a woman because there are women issues of women representation for marginalized groups. And why do you think the conversation keeps flowing in that direction at all times?
I think for a few reasons. So when we look at the composition of the International Court of Justice and also the European Court of Human Rights, the European Court of Justice, and other international and regional courts, there is a long-standing tradition, convention, sometimes rules, but usually practice is coalesced into rules of having each nation represented. So for example, there are 15 permanent judges of the International Court of Justice, and if you didn't have, say, Greece didn't have a judge on the court, and then Greece was taking Turkey to the court, and Turkey didn't have a judge on the court, they would also be allowed to appoint an ad hoc judge to sit. And so there's this long tradition in international law and regional law, supranational law, that the Italians deserve an Italian judge, and the Germans deserve a German judge, and the Indians deserve an Indian judge, and the Chinese, and it comes from this political science theory that you are not, that you're acting for, right? So there's different ways of thinking about your representation in your constituency, and Professor Sally Kenny does great work on this, developing this, and there are a few other professors writing on this topic about why are countries obsessed with having their own national deciding their case or arbitrating their case, because they don't trust, the Italians don't trust that the German judges will have their best interest at heart. Okay, and this is again hundreds of years of practice, if we just say 80 years in the current system of the UN. And that there's a kind of parallel there with gender, with ethnicity, with religion, with disability, with age. Is we assume that maybe it's sociological, maybe it's psychological, that someone that shares our experience, whether national or otherwise, will better understand the case that we bring before them because they have that lived experience. So that's one thing. There's a parallel there. And another thing is we do see, even if we don't have really robust database studies at the international level, that it's the women judges that bring these issues to the forefront. So Judge Navi Pillay is very famous for having stopped proceedings in the International Criminal Tribunal for Rwanda because the prosecution had not brought charges for sexual violence, but there was evidence coming out from a witness giving testimony of sexual violence, and she said, stop, gather the evidence, and come revise your charges and come back. And that started the law of rape and sexual violence under international criminal law in motion. And she's a human rights lawyer. and has her own story of practicing in apartheid South Africa and everything. So there's that's one anecdote. It's given over and over, but we have many more. Martinez said that recently we had a very important decision from Judge Charlesworth that highlights some possible outcomes, judicial outcomes of having an avowedly feminist judge on the bench who can bear witness to the lived experience of certain people in certain situations and who can write it into law. So there's a parallel with nationality. There's assumptions, right? There's intuitive feelings or psychological or sociological knowings. And then there is what we do see in practice. And those are two anecdotes, but we could gather many more. And Martina gave also the example of when Judge John Donahue was president of the International Court of Justice, and she stood before the Sixth Committee in New York, this international law week, and she said something very different than we heard from the current president, who's male. And she's also known for saying other things like that about the gender and sex of the lawyers standing before her in the International Court of Justice. So I think there's parallel, there's a feeling or a knowing, and even if we can't say there is data, there is evidence. And then finally, I would say, I think that lived experience is essential for competence. It doesn't mean that people with different lived experience can't empathize and can't understand. Of course, we want to empathize and understand with each other. And I think it is more likely that the person who grows up walking a mile fetching water from a well would understand access to water more than someone like me who grew up turning on a tap. It's just going to form part of our knowledge, our wisdom, and our perspective. And that's not a bad thing. So when we also think about the objectiveness rather of judges, their adherence to the rule of law, their faithful application of the law, it's not a bad thing. It's in fact the opposite. It's a very good thing to have a wide diversity of understandings of what that law is and how it applies in that specific case.
Thank you.
Yeah, thank you. I was intrigued when you said that you were not an instrumentalist.
Yes.
And so I was wondering what that meant, because if you're not an instrumentalist, then I guess the requirement of parity is a moral one. Equality is a human one.
I don't know. And I don't think we as a working group would make that argument. And I'm curious why you would ask that. For me, it only matters that it's a legal one. And it's a choice to frame it in terms of international human rights legal obligations that are black letter law. They're black and white, they're written.
Sure, but I mean, either if it's law or if it's variety, it's not instrumental, it's obligations.
I don't, right. I don't think look, there's a debate about the universality of international law and international human rights law. And I think there's other people who disagree and would think that we have there's a universal core to our morality as evidence in law. Prohibition on murder, right? Criminalization of murder, that sort of thing. For me, I don't see the value in assessing the moral obligation. For me, I see the strategy in reminding states and UN organs and bodies of their legal obligation. Now, we do have people coming. One of the reasons that this talk is framed, gender parity, feminist judging, the International Court of Justice, is because we have scholars arguing you're focusing on the wrong thing. There are moral obligations to have more feminist judges. So that's out there. And we have a lot of scholars, including ones we work with and we partner with, arguing instrumentally. More women will legitimize your court, and legitimacy of your court is essential for enforcement of your decisions and et cetera, and for the rule of law. And I think that
there are good instrumentalist arguments. I don't think humans are instruments. I don't think we put women in positions of power or anyone in positions of power because of what they'll do for you. I think that part of the patriarchy is looking at women and girls as what they will do for you instead of looking at them as human beings with rights. And so I really don't want to go there, and we don't have to go there because the law is clear. We don't have to use morality, we don't have to use instrumentality, and I think it muddies the clarity of the very fundamental legal obligations.
Yeah, just reply. But so, okay, so the normative, on the normative level, you place your framework at the level of legal applications. It seems to be excluding instrumentalist arguments. But at the same time, in your work as a scholar, you need to think strategically in order to influence.
Yeah.
Or so in order to bring about the state of affairs that you think is legally justified,
Yes.
grounded.
Yeah.
And also seem to refer to the effects that one might have on other issues.
Yeah.
You mentioned lived experiences and all of that.
Yeah.
So it's just to clarify the extent to which you are the ontological and the extent to which you are actually an instrumentalist.
0% instrumentalist. We think that undermines the argument. When I first started working on it in 2016 and publishing on it, there were a host of instrumentalist publications that were already out there, and they weren't focused on. There wasn't a concomitant working group or campaign or strategy working directly with this. We don't think as a working group that's the way forward. And I'm not instrumentalist. I'm not a utilitarian. Humans are humans, and humans have rights because they're humans. And legal obligations are legal obligations. And if you don't like the law, change the law. And this is the law. This is a human right.
Yeah, and I think even as a scholar, there are different kinds of strategies and different kinds of commitment that you can have that are beyond that. So, and I don't think, and you can choose different in your scholarship, different in your strategy as civil society. And different, so there are different levels you can ask, and these commitments do not necessarily clash. And there's no need for like clarity in that sense, I think, for me.
Yeah, and that's something. So we take a feminist approach, and one of them is, both and the dialectic, and more than one thing can be true at the same time. But we
don't need the binaries.
Yeah, but we do also have to be strategic, and I don't know. I don't think that the legal advisors are convinced about morality. And that's not on the agenda. That's not on the agenda at International Law Week of the United Nations.
And this is why in Europe saying also different hats. This is why I said, as a scholar, you can do different things. But then I think yes.
Yeah, thanks so much, both of you. So I was thinking at this point about presentation, and obviously like the comments that were made were very bad, and that's not where I'm going at all. But I wonder whether there's real worry that when it comes to geographical distribution of national background, there's no presentation anyway, because you keep having the permanent members, say the UK, but then having to object properly again. And they kind of like occupy the majority of the bench still.
Yes.
If you take into account even the one listing European state and the national judges, like there's a lot of Western involved, sort of, or adjacent on the bench. And I wonder structurally what this means in terms of get more women elected, because I don't think it's an accident to see that the women that have been elected, with the exception of Uganda's judge, have come from either permanent members or countries like Australia, right?
Yeah.
There seems to be some sort of like competition that if you put a woman forward instead of your most well-known because of structural constraints and inequality nationally and internationally, male candidate, probably you're going to see the seat. That might get otherwise. So I don't think that the two are competing. We should be thinking about that type of presentation and trying to promote it in pride, because unless we, to me, it's such an issue when it comes to you know, getting more people elected from those states that have different judges elected on the court, you're not actually going to get more women. And the women that you're going to get, they're going to be coming from Australia,
Yes.
UK,
Yes.
US,
Mhm.
maybe China, also.
Yes. It's a huge issue. And Martina was saying earlier, you know, what do? We map, we note, right? And then we strategize and we consult. So we've consulted with people that are candidates and people that have run before. And I was mentioning that it costs a lot of money to campaign. So I was mentioning the big, as you did, the big five, the permanent security council members, they want a seat. They fight for their seat. They throw money, a lot of money behind their seat. They have it. They have the money. And why? Because they assume they will get better outcomes at the court if they have their judge on the court, even though judges are objective and neutral, right? So how do we address this? And I wonder if you want to come back, because we are, one of the strategies is, which we don't have access to, but it is a strategy and it's worth writing about and speaking about, is a fund. Is to fund candidates from countries that don't have money to campaign themselves. So you also need the support of your ministry. They have to pay for your flights all around the world. They have to pay for your hotels. They have to pay for your apartment in New York, so you can stay there for months and campaign during the General Assembly and International Law Week. Even to hold an embassy reception, your permanent mission, a fireside chat with your candidate, will cost you $5,000 to $10,000 to have your embassy open at night and have the security. And and those things are often funded by law firms, by private practice, by feminists that care and want to support. So there's no structure. You know, UN Women used to be the UN Fund for Women, right? And they still fundraise. So the national chapters, like in the UK, will fundraise. So there's one idea is maybe a fund for underrepresented countries or candidates whose countries don't have that type of financial support to actually be strong contenders. And I would also ask you, what do you think? You know, how would you? Because that's what we do. We talk, we consult, we learn, we think, we strategize. What ideas might you have? Not necessarily now, but let's keep talking. But what would you say is a counterbalance to that? So again, we have to look at what we've got. We've got 3 women candidates out of 11 right now, 1 from Singapore, 1 from Kenya, and 1 from Peru. It's interesting, isn't it? And all the other, there's many other African candidates, and they're all men. And they've all taken a gender pledge, 1 gender equality awards. So what, I mean, this is real, this is structural, it's global, it's north-south, it's rich-poor, it's historical. It's an important point. I agree with you. And what do you think? How do we solve for it?
And then you cannot wait for the structural issues to be resolved in a way that, you know, this entails a long road. And this is why you try to engage on different levels and try different strategies. Yeah. Because the problem that you mentioned, if you wait for them to be solved on that deeper structural level, you won't achieve any change. But whether you can achieve that change in any case, because they are so deeply embedded, you don't know. You just have to try different strategies and you have to think, I think.
So I mentioned people told me that they originally thought, oh, we're going to solve gender equality in a couple of years, right? They have data that says that if current trends continue, there won't be gender parity on the International Court of Justice until 2056. So I named session 3 at the Hague workshop in September. I put it in something like, how do we go faster? Like achieving gender parity. And loads of people responded during session 3, we can't. And we're taking advice and strategy from people who are very knowledgeable about the UN system and even very experienced, say, in running side events with impact. And they said, you need a 10-year horizon. So these are things to keep in mind, right? This is an added layer. If we don't diversify the countries and the region the judges come from, we're also going to be undermining women's parity on the court and intersectional parity on the court. And that we have to embed that in our longer term strategy and kind of work
multi-level and take whatever, whatever road is opening at the moment, take that path.
Okay, any final questions? Because we started a bit late, but I don't want to hold you the entire night. It's getting dark early now.
So, I understand we're talking about gender parity at the ICA, but my question is kind of general.
Yeah.
What would your advice be to a student or an aspiring academic? Since you said that this is, achieving gender parity is an international obligation.
Yeah.
It is a collective action.
Yes.
Problem. Everybody needs to do this, and the message needs repeating for as long as it takes. I mean, more talks like this, definitely.
Yeah.
But what can one do at, at a micro scale, say at an individual level?
Yeah.
If they want to, say, further the awareness. Further the, let's call it a mission.
You could talk about it, you could tweet about it, you could post about it, you could write your term papers about it, your coursework, you could write your dissertations about it, you could publish about it, you go on podcasts about it, you can write to your MP about it, you can write to your ministers about it, you can get involved in our working group. I mean, we are going to need, or not necessarily, but one potential strategy for change is a certain percentage of the population tips over and is clamoring for this, and that tips over a certain percentage of states that will be nominating and casting the votes. So it is possible that from the ground up, students, law students, early career lawyers or early career researchers or academics could be raising the issue. General recommendation 40, I highly recommend it, 29 pages, and it has a section on youth. It said any future looking strategy for achieving parity must involve youth. It's got a few paragraphs on that. Because if we don't train, I mean, but that's been actually, I don't know if you all know this, but for decades, women have outnumbered men in law schools. So that's not our problem. But anyone can raise it, right? So, and anyone can call attention to it. And you said, if you want to be an academic, you could write about it. It's already come up in this room that there are many different angles. Our angle isn't the right angle, it's just the angle we've chosen, and we're willing to pivot at any moment where it seems like we, change our beliefs or our knowledge or the structure changes. So anyone can get involved in that for sure. Or involved with us.
Thank you all. Jessica, if you don't want to say any last words, I will close the session for now. And thank you so much for your insights and deep knowledge about all of the topics and your strategizing and sort of tireless work, because I've watched you like campaign and write and do a million things together. And thank you for managing to arrive here.
Yes.
Thank you. So thank you everybody for coming.